go to the second ground of appeal, which is the issue about conviction.
Ngcukaitobi, I just want to warn you that your 10 minutes is up now. You may expect questions from the members of the bench.
Indeed.
But proceed.
So we then go to the second issue, which is the issue of the conviction. Now, what we know here is that under Section 47, subsection 1, subsection E, the text of the Constitution says anyone who, after the section took effect, is convicted of an offense. We will deal with sentence in a moment, but let's stick now to convicted of an offense. We had the argument. The way we understand the argument is that if you have not been convicted following a criminal trial, which has Section 35 rights, you are not convicted for the purposes of Section 47(1)(e). When we say that the argument is plainly absurd, a contempt of court, and we've referred to a number of these judgments, perhaps I should, yes, in the Faki judgment, which now what happened is that I've lost my own bundle of authorities, but let me do this. So the Faki judgment is at page 14. So in the Faki judgment at paragraph 6, 10, and 12, and in the authorities bundle, you'll find the Faki judgment from page 14. So at paragraph 6, 10, and 12, so those paragraphs you will find from page 18 and 19. So that's where Justice Cameron analyzes the contempt of court, and he says that it is a crime. In fact, in paragraph 6, he says, it is a crime unlawfully and intentionally to disobey a court order. This type of contempt of court is part of a broader offense, which can take many forms, but the essence of which lies in violating the dignity, repute, and authority of the court. So it's quite clear there that it's described as a crime. You also find that at paragraph 10 of that judgment, page 19, and you also find it at paragraph 12, which is also at page 19. So it's described as a crime, as an offense in Faki. The same position applies in the PECO judgment of the Constitutional Court. So that you will find at page 127 of the authorities bundle, 127 to 148, and particularly at paragraphs 28, 30, and 31. And in all of those paragraphs, contempt is referred to as a crime or as an offense. Even in the Zuma case...
excuse me, Mr. Ngcukaitobi, please may I have the paragraphs again?
Yes, it's paragraph 28, 30, and 31 of PECO. And PECO you will find at page 127 to 148 of the authorities bundle. So contempt there is described as an offense or as a crime. Now, even in the Zuma contempt case, which is also included in the bundle of authorities, but it's also part and parcel of the application itself. And I'll show your leaderships. So the judgment is at page 263 of the bundle of authorities. So you will find again there contempt of court at paragraph 61, 66, 93, yes, 61, 66, and 93. It's described as a crime and as an offense. Described as a crime as an offense. And so it's clear in our law that if you look at the first requirement for section 47(1)(e), which is the offense part, right? It is contempt of court an offense. It's clear that it's an offense, it is a crime. Then you are left with well convicted. So people are only convicted of crimes. They are not convicted of anything else. They are convicted of crimes. The procedure for the conviction has no bearing on whether they have been convicted or not. What we know for contempt is that the procedure is hybrid. And we know in the judgment of Justice Khampepe in the Zuma contempt case, that what she said was that it is a hybrid. It's part criminal, part civil. But that's the process. But the substance of it, when there has been a declaration that you are guilty of the crime, that is a conviction. It's as simple as that. You find this in another judgment also, which we have cited, which is the Middle Glen judgment. And you will find the Middle Glen judgment in our bundle of authorities. It's item 8, page 87. And when you look at paragraph 16 of Middle Glen, it's clear that they talk about a conviction for contempt of court. And that's the Supreme Court of Appeal judgment, which you will find at page 87 of the bundle of
Paragraph
authorities.
16, you said.
Paragraph 16 of Middle Glen, yes. Paragraph 16 of Middle Glen. And it's at page 87. That's where it starts, but you are looking for paragraph 16. So we now know that for contempt, you are convicted. Contempt is an offense, contempt is a crime. In this particular case, Justice Modiba was raising this point. We only have to look at paragraph 142 of the judgment of the Constitutional Court. And that's paragraph 142 where the order appears. So that you will find at page 297 of the authorities bundle. And so after all of the analysis, the paragraph 3, subparagraph 3 of paragraph 142 says, it is declared that Mr. Jacob Gedehlegisa Zuma is guilty of the crime of contempt. So there is a clear declaration that he is guilty of the crime of contempt. So it could have said he is found guilty of the crime of contempt, but that is a conviction. There can be no debate about that. It is a conviction. It is irrelevant that that conviction came through the civil process. That is how contempts are litigated. What is relevant is that contempt is a crime, and Mr. Zuma has been found guilty of that crime. So when we go back then to section 47(1)(e), we look at those words, convicted of an offense. So we only have to answer there. Was this an offense? The answer to that is yes. Was there a guilty finding in relation to that offense? The answer to that is yes. So we are dealing with someone who is a convict, convicted of an offense. The next question then, so that should be the full answer to the conviction complaint. It is a conviction complaint, but the conviction complaint has no bearing whatsoever. Now, it is true that that is not appealable. That is what the Constitutional Court found. And it knew that it was not appealable. Mr. Zuma argued there at the Constitutional Court that it was unfair to convict him for contempt when he had no right of appeal, but the Constitutional Court decided against it. So here we say it is not open to this court to revisit. I heard Mr. Mbofu saying he is not revisiting, but in substance, when you listen to him, he is revisiting. Because he even said that it was an unconstitutional finding. He even said that, these words, unconstitutional finding. Now, what would be unconstitutional is for the Electoral Court to depart from the judgment of the Constitutional Court.
Sorry, Mr. Ngcukaitobi, but that judgment did not specifically deal with 47(e), in particular regarding the aspect of whether that sentence conviction could be appealed or not. What's your take on that?
Yes, it did not have to deal with it. It only had to deal with whether or not, in the presence of the Constitutional Court, he had a right of appeal. Because you must remember what happened. Mr. Zuma was guilty of contempt of an order of the Constitutional Court. So it's only that court that could address his contempt.
But
Yeah,
Mr.
he's
Ngcukaitobi,
sorry.
but do you accept that under normal circumstances, a conviction which follows on the contempt of court proceedings, that conviction would be appealable?
Yes, I accept that. It's
But
clear on the law.
it's because of the situation in that particular case, peculiar situation, that the court that convicted him was the
Yes,
apex court.
precisely.
And then he had no
No, but he did
Court of
complain.
Law, yeah.
He did complain before the Constitutional Court.
Yes.
There is a full analysis of that judgment. He did complain, and that issue was dealt with and resolved. It's not as if it's being dealt with for the first time here. The issue about his right of appeal was a subject matter of debate.
But now, within the context of Section 47, 1E, doesn't that have the effect? Don't you, well, what does that do to Section 40? Let me put my question this way. What does that do to Section 47, 1E? Because Section 47, 1E does refer to an appeal. In other words, a conviction must be a conviction which has been subject to an appeal, a sentence that has been subject to an appeal, and the appeal was dismissed or the appeal was upheld and the sentence was reduced.
Yes, but we know. Sorry,
Yes. Go ahead, that's fine.
no, we know here that that issue of whether or not he had a right of appeal was debated, found against Mr.
Yes.
We also know that he, in fact, attempted to rescind, also raising the very issue of the appeal. And even on that decision, that was dismissed. Now we come back to Section 47, 1E. It's simple the way it applies. Of course, if there is an appeal, we must look at whether or not, and you remember that if you look at the section 47, 1E, what it says is that you have to take into account the appeal. So go back to the actual word. Anyone who, after the section took effect, is convicted of an offense and sentenced to more than 12 months imprisonment without the option of a fine, either in the Republic or outside the Republic, if the conduct constituting the offense would have been an offense in the Republic. But no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined, or until the time for an appeal has expired. So what it simply does, it simply allows the period of a conviction for a person who has been convicted to appeal it. But it even says, or the time for that appeal has expired. It's clear that where there is no appeal as a matter of law, that period will not be applicable. So it applies where there is an appeal, it applies where there is no appeal. But where the Constitutional Court has decided in this sentence, in this conviction, there will be no appeal. That provision, what all it does is, we are not going to implement it now because we're going to wait for your appeal. But there is no reason to wait for the appeal where the Constitutional Court says we are the final court and there's no appeal.
But is it a proper way of interpreting a statute where you interpret it according to what had happened in a particular case?
No.
Because, I mean, obviously people need to know where they stand in relation to the application of Section 147. They can't decide their case on the basis, well, in this situation, this is how the section must be interpreted. But if this situation applies, it must be interpreted differently. Surely that's not the correct way of interpreting the statute.
No, but my Lord, what we submit here is that if you took the view
Yes.
that the judgment of the Constitutional Court on contempt does not apply, so Section 47(1)(e) does not apply to it because there is no appeal. If you did that, you would in fact be rewriting the Constitution, which is actually a worse position to be in. What we are asking the court to do is to give effect to the words of the section. It's clear that where there is an appeal, the section does not come into operation because you have to wait for that appeal period to either be brought or to lapse. But in circumstances where the highest court has made a determination and it has considered that appeal, the section still applies. The section is never excluded. Because the only way to get to that conclusion is by arguing that Section 47(1)(e) is excluded in the case of contempt of court criminal findings by the Constitution. That we say is untenable.
Mr. Ngcukaitobi, would you say that this provision deals with several scenarios?
Yes.
Right? So the first scenario is that a person is sentenced, right? Which is the scenario here. There was a sentence imposed. Following the imposition of a sentence, two things could happen. An appeal could be lodged,
Yes.
right? Which is essentially a petition
Yes.
by the convicted person
Yes.
seeking either a reduction or complete setting us or an interference with the sentence that has been imposed, right? But then there could be a third scenario where it's uncertain. There's uncertainty regarding what's going to happen because the window for appealing is still open, right? That's why the proviso further reads until the time for an appeal has expired. So it deals with several scenarios. But given what has happened there, that there are no prospects of a further appeal, these scenarios are simply not applicable. They're irrelevant.
Yes. No, I would submit, my lady, that it's clear that in this particular case, the section applies. The section does not apply simply because the imposition of the sentence.
No, I'm with you. I'm putting it differently.
Okay, yeah.
I'm saying it's dealing with scenarios that are irrelevant given the facts here.
Yes, to the facts.
Because he couldn't appeal.
Yes.
So the fact that there was no appeal to be determined.
Yes.
That's the second scenario. There was no, he had been sentenced.
Yes.
That's first scenario. Second scenario is that an appeal had to be determined if it was pending.
Yes.
But that's inapplicable because he couldn't appeal
Yes.
further.
And
The third scenario is that the period for appealing must not have expired. But that scenario also is irrelevant here because he simply could not appeal.
Yeah. And my lady, to add this, and I've said this to the court already, the appeal was debated, fully debated at the Constitutional Court. It was debated.
But even if it was not, just on a simple interpretation of the effect of the sentence imposed by the Constitutional Court, it's the ultimate sentence,
Yes.
right? At this point, I'm not dealing with the intervention by the President.
Yeah, no, I'll deal with that.
We're simply dealing with the sentence
Conviction.
as imposed by that court, yeah.
No, indeed.
Sorry, Mr. Ngcuka, my sister on my left has got a question for you.
It's fine, Mr. Ngcukaitobi. I think.
Thank you, my lady, for actually pronouncing the full
Oh,
sentence.
sorry. I'm sorry. Sorry. Yeah.
No, it's fine. We've passed that point, and I don't want to take us back. You can proceed.
Okay.
Or the point you had a question on?
Yeah.
All right,
Sure,
thank you. All right, so I think we can leave the point at Justice Modiba's summary. So where we are right now is under Section 47(1)(e), he has been convicted of an offense. The fact that there is no appeal is irrelevant. The section cannot be written out of the Constitution simply because there was no appeal. What that leaves us then is the sentence part. Now, the way we understand the argument to be